Thank you, Marya. And first of all, thank you to Franciscans International for arranging this event and for inviting me to participate in it. What I'm going to do in my presentation is to refer to a case that was filed in South Africa last week, a class action, in order to illustrate, unfortunately, yet another example of the devastating impact that mining operations can have on the environment. The obstacles, some of the obstacles to justice that victims face, and why there is a need for a legally binding instrument. I want to start first of all with a short film about the case, because I think that will explain things much better than I'm able to do. Okay, let's show the film.
Over 230,000 people live in the lead-contaminated town of Kabwe, Zambia. This was home to the world's largest lead mine for 80 years and was part of the Anglo American mining company group from 1925 till 1974.
There were serious deficiencies in control of lead emissions, which resulted in widespread contamination of the environment. The public health disaster that has entailed the poisoning of generations of children in the local communities was entirely predictable.
When they left, as a result of their operations, they have left an environmental disaster. When you look at the Clark study in the 1970s and the blood lead levels then and to the blood levels now, nothing has changed. So the very same lead poisoning that was happening at that time is continuing happening now. Studies have shown that the soil in the township surrounding the mine has concentrations of lead more than 150 times higher than the relevant international standard of 400 milligrams per kilogram. Children are most at risk of lead poisoning because their brains and bodies are still developing.
The younger you are, the greater the risk. When a child is exposed in those early years, they can live their whole lives long with a damaged heart, damaged kidneys, and with impacts on the brain. And that cognitive loss is often permanent.
Lead in the blood is absorbed into the bones. During pregnancy, this lead is released. It crosses the placenta, causing harm to the unborn child. This is a serious risk for all girls and women of childbearing age in Kabwe. There is no safe level of lead in the body. Mental impairment can occur at levels as low as 5 micrograms per deciliter. Treatment is required at 45 micrograms per deciliter. Levels in excess of 100 micrograms per deciliter can be fatal. Various studies have shown that in some areas of Kabwe, all children under 7 have been found to have levels above 5 micrograms per deciliter. Around 50% have levels greater than 45 micrograms per deciliter, and many have levels above 100 micrograms per deciliter.
At those levels, you could expect to see convulsions, coma, permanent muscular paralysis, and that child could die.
Anglo today subscribes to human rights principles. Unfortunately, Anglo's practices at Kabwe seem totally at odds with its public commitments.
Okay, yeah. Now, if you want to look at that film, you can find it on the Children of Kabwe website, which is devoted to the case, and also that website includes other information about what has happened at Kabwe, including the court papers that have been filed as well, if you're interested in those. So an application to certify a class action has been filed in the Johannesburg High Court. You saw the South African lawyers who are running the case. Lee Day is assisting Mbuyisa Malile in that case. And the claim is a class action, and there are two categories of claimants. First of all, children under the age of 18 who have suffered harm from excessive lead exposure, and also women who have had children or will have children in the future and who have suffered excessive lead exposure. And according to a statistician expert who has produced a report for the case, her estimate is that the size of the class may be in excess of 100,000 people. So it's had a huge impact on the local community. Now, this is a mine, the Kabwe mine, which operated between 1915 and 1994. And for most of that period, from 1925 to 1974, it was owned and operated by a company within the Anglo American South Africa group. The case is against Anglo American South Africa, I should have said at the beginning. From 1974 to 1994, the mine was operated by a Zambian state-owned company, but according to experts instructed by the claimants, they say that most of the current pollution in the area emanates from the period when it was an Anglo mine or a mine within the Anglo group. The allegation in the case is that Anglo American South Africa is liable because it managed and controlled and gave medical and technical advice to the mine, and that deficiencies in those aspects resulted in contamination of the local environment, and because the risk of lead poisoning of the community was obvious due to the close proximity of the villages to the mine and the magnitude of its operations and the way in which they were conducted. Anglo American is now headquartered in the UK, as many of you will know, and that has been the case since 1999. So there's no liability on the part of the current head office parent company, Anglo American PLC. The case, as I say, is against Anglo American South Africa, which is the former Johannesburg-based head office parent company of the group. It's the company which presently holds all the South African assets of the Anglo American group. Can we just have a look at the first slide, Thomas? Right, okay. So this is an extract from Anglo American's current group human rights policy. And you'll see the statement there that where we have caused or contributed to adverse human rights impacts, we will contribute to their remediation as appropriate. Now that corresponds to the responsibility under the UN guiding principles, which is under Pillar 2, paragraph 13 specifically. So this is a policy which presumably is in response to the UNGPs, which Anglo American supports. So that's the first observation about the UNGPs. Now, secondly, again, as most of you will know, Pillar 3 of the UNGPs, access to remedy, includes a section on legal barriers to remedy, and one of those, in paragraph 26, concerns the barriers that are the legal barriers between different corporate entities within a multinational group. And so what paragraph 26 says is that legal barriers that can prevent legitimate cases involving business-related human rights abuse from being addressed can arise where, for example, the way in which legal responsibility is attributed amongst members of a corporate group under domestic, criminal and civil laws facilitates the avoidance of appropriate accountability. So that's a reference to what lawyers refer to as the corporate veil, or the corporate veil obstacle. Can we just have a look at the next slide, Thomas? So this is a statement that was put out by Anglo in response to publicity about the case last week. And you can see here that they said they would review the claims and take all necessary steps to vigorously defend its position. So Anglo said it was one of a number of investors in the company that owned the mine until the early 1970s, when it was taken over by the Zambian government. But it was at all times far from being a majority owner. Furthermore, in the early 1970s, the company said that it owned the mine the owned mine was nationalized by the government of Zambia, and for more than 20 years thereafter, the mine was operated by a state-owned body until its closure in 1994. But in relation to the first point, this is the problem that I alluded to a moment ago concerning the corporate veil. So what Anglo seems to be saying here is that it's not legally responsible because it was just an investor. Now, and this is the exact argument that is specifically identified in the UNGPs, which Anglo American supports as being a significant barrier to justice in these cases. Now, you know, a company obviously has a legal right to defend itself, and I don't think anyone could have an issue with a company which makes a defense on the basis, for example, that the claimants didn't suffer any harm, or that the operations were not conducted negligently, or that the harm was entirely someone else's fault. I think the company that wants to make those arguments is perfectly entitled to do so, but to rely on these technical barriers between subsidiary companies is, as I say, exactly what the UNGPs identify as a significant problem in terms of access to justice. Now, I've used the Cadway case as an illustration, but Anglo American's approach is far from unique. Indeed, in the vast majority of cases that Lee Day has done over the past 27 years against multinationals, the companies have raised jurisdictional and corporate veil objections. And one just has to look at the cases we've run against Shell over the oil pollution in Nigeria, Vedanta concerning the copper mine operations in Zambia, and Cape PLC for South African asbestos miners many years ago. Now, companies presently have a legal right to raise these objections, but these objections do negatively impact on victims' access to justice, and it's therefore hard to reconcile that stance and those objections that are taken by companies with the commitments that business has under the UN Guiding Principles. Overcoming these access to justice obstacles requires huge resources and expense and expertise in cases which are invariably complex and substantial and hard fought by defendants who have the benefit of armies of lawyers and technical expertise. In the case of Cadway, hopefully the Cadway claimants will have the benefit of South African class action procedures, a team of experienced lawyers, as well as funding, litigation funding, which has been made available for this case from Augusta Ventures. But these kinds of advantages are not usually available to victims of multinational operations in developing countries. And a system in which multinational corporations subscribe to the UNGPs on the one hand, but at the same time behave and defend cases in a manner that is contrary to the UNGPs, in my view, demonstrates the need for a legally binding instrument. Thank you.
Thank you very much, Richard. And also thank you to Richard and Lee Day for co-sponsoring the event today. For all of the participants, you can feel free to start putting in questions as they arise, and then when the Q&A period comes up, we will be referring to them, but don't hesitate to begin now. Liliana?
Yes, good afternoon. Thank you for the invitation. First, I want to say that I speak on behalf of Rodrigo Pino and the communities of Arica. So indeed, I work for the organization, but today I represent them. And I'll speak today, if you please can start sharing the presentation, Thomas. Thank you. I'll speak today about a case in North Chile, Arica, and I'll spend 10 minutes, around 10 minutes, taking you through a lot of information in a legal case. I'm not a lawyer, so I prepared a presentation to outline the information. And it's about toxic waste and justice for communities, a case that goes back to the end of the 80s in Chile, in Sweden. So first slide, please, Thomas. So first of all, a short description of the facts. Between the year 1984 and 1985, a Swedish company named Boliden shipped more than 19,000 tons of toxic waste containing arsenic, mercury, lead, cadmium, and other metals from Sweden to North Chile. The shipments were made with the knowledge of the Swedish Environmental Protection Agency. Boliden exported the sludge for processing and arsenic extraction to a subcontractor, a Chilean company called Promel. The exact details of the contract are unknown, but according to a recent report produced by the European Parliament, Boliden paid Promel around €1 million. Of the 19,000 tons of toxic waste, only 120 were processed. The remainder of the waste was left outdoor, uncovered. Can you please share the next slide, please? In a site known as Sitio F. You see on the left side of this picture a red arrow, that's the Sitio F, and this is a recent picture of Arica. 250 meters away of a neighborhood of a low-income family housing called Sica Sica. And it remained there for almost 14 years. The surrounding community was never advised that the material was toxic. And families used some of the material to level their gardens, their patios. And the waste pile also became a playground for for children. So the first picture that you saw at the beginning of our presentation was taken there, and you could see the children playing with the waste. In 1997, toxicology samples shown that the site revealed high levels of arsenic, mercury, lead, cadmium, zinc, and copper, among other heavy metals. In spring 1998, the Chilean state relocated the waste pile from the Sitio F to a location known as Quebrada Encantada, which is on the right side here in the picture, the current site, to the east side of Arica, which is approximately 650 meters away from another neighborhood called Cerro Chuño. It stays there, it's open, and it's accessible and exposed to the elements. In the same year, in 1998, the Chilean government estimated that approximately 5,000 people have been exposed to dangerous toxins. In 2009, it identified an array of illnesses and health conditions within the community, including cancers, pain in the joints, bones, chronic coughs, anemia, and allergies. Many of the women who played on the waste pile and children have been unable to conceive. They experience high rates of miscarriages. Many of these, I recognize many of the examples also given in the first presentation. Also, the babies that were born have visible neurological disorders, and some of them have spina bifida. As I said before, this site is still open for the public, and it's uncovered and unprotected and exposed. Next slide, please. I would like to take you now through the legal procedures that started in '99. In the first attempt that was initiated in Chile to provide justice. In 1999, 960 residents sued Promel and the health authority of Arica for the damages suffered. In 2007, the Chilean Supreme Court ordered Promel to restore the site, but Promel went bankrupt and nothing happened. The restoration of the site was not undertaken. The court also ordered a compensation paid by the Chilean Health Authority of 8 million pesos, which is approximately 10,000 euros for more than 300 people. A continuation of the case in Sweden, a legal case was also brought against Boliden in Sweden by the victims, which organized themselves in a collective called Arica Victims in order to bring claim in Sweden. In March 2018, despite finding Boliden negligent in continuing sending waste to Arica, the court in Sweden concluded that the victims failed to demonstrate the link between their toxic waste and their arsenic in their bodies. And the decision was appealed by the victims. Next slide, please. In spring last year, the court appeal in North Sweden determined that the Swedish law should apply in this case. And under that law, the claims of the victims were time barred. In the Swedish law, a law claim is time barred after 10 years after the act that gave rise to the alleged harm took place. As we know, chronic arsenic poisoning occurs as a result of long-term exposures. That some problems are visible after years of exposure, and 25 years is what we know it takes to manifest themselves, the health problems. As a result of this court decision, what means is for some of the victims that were not even born at that year when this happened, the crime itself is time barred. The Supreme Court of Sweden refused to leave the appeal. Finally, Boliden sought to recover the financial cost from the community, asking the sum of more than 3 million euros. The company that was formed by the victims couldn't pay those costs and is now bankrupt. In December 2019, the ban amendment was passed, prohibiting any movement from toxic waste from a developed country to a developing country. As we know, 90% of the world hazardous materials are produced in developed countries. Unfortunately, for the Arica victims, in this case, this came too late. This case shows different types of responsibilities from companies, governments, and international communities. But still, up to this day, the communities have not seen any justice. Next slide, please. The communities sent a letter to the Swedish government asking 4 things, including the repatriation of the waste from Chile. As they say, this material is not theirs. It should go back to their country of origin. Of these 4 questions or requests, only the first one is met. The Swedish ambassador visited the site this year, at the beginning of this year. All 3 are still pending. Finally, I want to share with you a documentary that is being made about this case, if you want to know more. And it's called Arica. And Thomas, if you please show the final. The Arica documentary, I consider myself part of this, the impact team. It's selected to the IDFA documentary festival this month in Amsterdam, and recollects years of investigation, and it shows in a very human way what the implications are for all the actors in this case, lawyers, communities, and also fellow humans from both countries. So I want to leave it here, and any questions? Open for any questions.
Thank you, Liliana. I actually just watched the documentary on Enrica, and I encourage everyone to also watch it, and perhaps we can send it out when we email the link to the webinar. Next, we have Marcos, and I just also would like to note our thanks for the co-sponsorship by the mandate today.
Thank you very much, Marya, and thank you to Franciscans International for convening us today to speak about these very serious issues. In my time, I thought I'd take a moment to reflect on what the Treaty on Transnational Corporations and Human Rights can bring to address the kinds of cases that we've heard about today, and other cases that concern environmental issues. By way of starting point, I think it's self-evident that many instances of human rights abuses by corporation concern environmental risks and harm. And so with that in mind, the treaty should respond to those instances of abuse. What should it contain? How is the current draft faring against that optimal vision? Let's break that down in a couple of components. First of all, on scope, there's been much discussion on this wording of environmental rights, that the treaty should cover human rights abuse, including environmental rights. Now, there can be a debate about the wording, but there cannot be a debate in terms of the environmental dimensions of human rights law. Human rights obligations concern a clean, healthy, and sustainable environment. Several of these obligations have been codified in an authoritative way by Professor John Knox, the previous special rapporteur on human rights and the environment, in the framework principles on human rights and the environment. So there's a good basis for identifying the content of environmental rights in that document. And there's a good basis to go beyond that in regards to the right to a healthy and sustainable environment. So that's the first point on scope. A second one is on who are the victims. Currently the draft speaks, and I quote, any persons or group of persons who individually or collectively have suffered harm, end of quote. So that raises the question, what about people that have been exposed to the risk of harm due to hazardous substances? They may not have exhibited harm yet, as the cases show, both by Richard and Liliana. It may take years for people that have been exposed to exhibit health symptoms. They may be also acute instances, but the instances may be latent, they may be chronic. So people that have been suffered exposure to risk, is that covered or is not? Would that be a debatable issue? It is worth here to recall that much of the law in the interaction of human rights and the environment is premised on risk and prevention. Once a government becomes aware of risk, it is under an obligation to take measures that are adequate to address it. And so thinking about victims in terms of risk is also an important point. So that in terms of scope, sorry to be rushing, the time is limited, but I'll jump very quickly to questions of access to justice and remedies, which are central to the treaty. And the first point I'd like to make there is in terms of prevention and the role that criminal responsibility can play as an effective deterrent. Because if we're talking about just administrative fines or even monies out of civil litigation, they may be factored in the cost of doing business. They may not be sufficient as an adequate deterrent. If we take an example of the Brumadinho Dam in Brazil, this is was owned by Vale and operated by Vale, the giant company there, that failed in January 2019, killing more than 200 people, 270 people died as a result. the risk of that dam failing was wholly foreseeable. A similar dam had failed a couple of years earlier, the Mariana Dam, affecting 3 million people in San Marco. So the knowledge of the dams being at their limits is well known. This is no doubt reckless conduct, but is it criminal? Now there's a question there. But if we look at the evidence that has shown up and the fact that Vale falsified documents regarding dam safety, there's a very clear argument that this goes beyond negligence, and civil liability and criminal responsibility can operate as an effective deterrent. So that's a first point in terms of prevention and criminal responsibility. A second one is on injunctions as a remedy and compliance with standards. In this regard, causation is often an insurmountable bar for the victims of exposure or environmental harm. And that is also where the precautionary principle that has been articulated in environmental law and statutes at the national level and at the international level is relevant. If we take an example here, the Cerrejón mine in Colombia, the biggest coal mine in Latin America, the Constitutional Court of Colombia in December of 2019 heard a case brought by the members of the indigenous peoples resident next to the mine, the Wayuu people, and the court reasoned that well, the company argued, as many companies do, that there was no proof of causation between the health impacts that the victims were suffering and the operations of the mine. And the court reasoned that it wasn't bound to strict causation because of the reversal of the burden of proof and the precautionary principle. And on that basis, it afforded protection by way of injunctions to the Wayuu people. It required, for example, the company to go beyond the national levels of air pollution and uphold WHO, the World Health Organization, standards of air quality. Now, this is also relevant for questions of due diligence, human rights and environmental due diligence, but I will not get into those elements in this discussion. I will continue to focus on access to remedies. So that by way of injunctions. When it comes to reparations and compensation, as mentioned earlier, causation and the burden of proof can be a serious hurdle, as has been demonstrated by our previous speaker, Liliana, in the case of Arica, for example. Now, in that respect, the Escazú Agreement concluded recently in Latin America and the Caribbean on environmental rights, so this is access rights to information, participation, and justice, contains a very interesting provision on access to justice that provides for the possibility of the reversal of the burden of proof and the dynamic burden of proof. Now, the reversal of the burden of proof can operate when there are serious evidence that points to the kicking in of the precautionary principle. For example, and in that instance, it would be the company, the operator of an activity that causes risk or harm to prove that that the harm was not caused by it or that its operations are safe. But perhaps even more interestingly is the dynamic burden of proof, which is a theory on burden of proof that has been elaborated by courts in Latin America that point to the burden of proof being allocated not in the traditional sense of the person or the actor that makes an assertion of fact or a defense bears the burden of proving it, rather who is in the best place of proving a fact. And often it is the case that it will be the company in the best place of proving a fact because it is under control of the operation. Given time, I will continue very quickly to a couple other points. Strict polluter liability. So once causation is established, including under reversal of the burden of proof and dynamic burden of proof, the strict polluter liability for all remediation costs and harm suffered to victims does away with having to establish negligence, which can operate as another hurdle in the victim's struggle to access justice. In the environmental field, such strict polluter liability exists for ultra-hazardous activities, for example, but not only for ultra-hazardous activities. There's the 1973 treaty, for example, between Argentina and Uruguay that contemplates strict liability for any pollution of the waters. Two more things. The statute of limitations can operate as another bar. We've heard that in the Arica case. This is particularly problematic in regards to toxics and latent diseases that may take years, decades to exhibit harm in victims. The current draft reads, and I quote, "or when the harm may be identifiable only after a long period of time," as an exception to a statute of limitations. Now, that language, in my view, should be tightened significantly to address questions of hazardous substances and wastes. Now, there's also the question of repatriation of waste, restoration, effective restoration. Now, under the Basel Convention, the illegal transfer of hazardous waste is a criminal act, and one of the remedies is the taking back the waste. Now, at the time the movement of waste from Sweden to Chile took place, the Basel Convention was not in force, but yet it can also be argued that these provisions can kick in when the harms begin to be felt. And in any event, these issues do not go away. The moral responsibilities will be there and they will not become stale. The last point I'd like to raise before closing, and I realize I'm almost a minute over the 10-minute mark, if I may, is in regards to the right to science, which I find no expression yet in the draft, but disinformation campaigns for profit by businesses, the distortion of science, the manipulation of regulatory process, they deprive society from the benefits of scientific progress. The Committee on Economic, Social, Cultural Rights has produced a general comment on the right to science, and it has pointed out to the importance of the use of scientific evidence in decision-making and policies. So there's a duty of states to ensure that private parties do not distort scientific evidence or manipulate processes that perpetuate exposures. And this should find expression also in the draft. So very quickly to conclude, the Treaty on Transnationals cannot ignore, should not ignore, or should not poorly address environmental issues. Thank you very much.
Thank you so much, Marcos, for your analysis on the cases in light of the legal gaps that are currently present. And Franciscans International, like you, also hopes that the next draft will address some of the issues that you raised today. And we're going to go to the question and answer period, and we already have quite a few questions. So I'm going to just, because of time, read 3 at a time and then go to our panelists. So the first question, which was sent during Richard's presentation, is from Margaret O'Dwyer, who says, "Is the government immune?" The next question, and this seems to be for all panelists, are human rights violations subject to lapse of time under international human rights law? And the third question, again for Richard, from Malcolm Roji, who says, "I'm wondering if you can elaborate on how the treaty mechanism can address the apparent contradiction that you noted in your presentation. Specifically, given the complexity of global corporate groups that overlap multiple jurisdictions, how do you see the overarching treaty mechanism addressing the corporate veil issue in the global context, such as for meaningful impacts on diverse domestic, local corporate law and civil liability frameworks?" He goes on to explain a little bit, but due to time, I think we can stop there and go to the panelists. Richard, if you would like to start, perhaps.
I'm just trying, right. Yeah, just in response to the first question, whether the government is immune, I presume that's a reference to the potential liability of the Zambian government. As I indicated in my talk, the mine was operated by a Zambian state-owned company for the last 20 years out of a total of 80 years. And what the experts who have evaluated the case have said is that the contamination that is presently in the environment is going to correspond to the levels of production that took place across the whole period of the mining operation. And what they've estimated is that approximately 22% of the production occurred during that latter period, which means that the current environmental contamination is 22% the result of operations during that last period. So that's the first point to make, that it's only a relatively small percentage of the contamination that arose then. Second point is that the claimants are bringing their claim in South Africa, and that is for good reasons. Not only due to the domicile of Anglo American South Africa, but also in terms of access to justice. South African courts have well-developed procedures over the last few years for opt-out class actions, which means you don't have to file claims on behalf of each and every individual claimant. And by the way, that would be an important feature, I think, of a binding treaty. It's not in the current draft anymore, the ability of claimants to bring class actions. But in order to gain access to justice, these claimants have to file in South Africa. They have litigation funding for that purpose. I should imagine that the Zambian government would be immune from suit in South Africa. So that's on that point. Do you want me to deal with the other 2 points while I'm talking as well, or?
Sure. How about if you answer Malcolm's question, and then we can go on.
Malcolm's question about civil liability. Well, I think the answer is in the current draft, actually, and in the UN guiding principles, which suggest a form of responsibility which is very much along the lines of the principles that have been laid down in the English parent company cases that we have brought over the last few years, or over many years, in fact. And this is the idea that a parent company, a multinational parent company, can owe a legal duty of care in circumstances where it exercised control or sufficient degree of control or management or supervision over aspects of local operations which were relevant to harm that was caused either environmental or otherwise. And that duty then requires the parent company to carry out certain steps and to take certain measures to ensure that harm, foreseeable harm, doesn't arise. And if it doesn't take those steps, then liability can be incurred. Now that's essentially the principle that has been established in the Vedanta case last year by the UK Supreme Court, and I think is the same model that features in the UN guiding principles and in the draft treaty. So that's, I think, what is being suggested as a global route to potential liability of multinationals.
Thank you. And for the last question from Rose, are human rights violations subject to lapse of time under international human rights law? For any of the panelists. Marcos, perhaps?
Yeah, I'm happy to take that. And I would say that they're definitely not. The human rights violations cannot be wished away. I'm sure the perpetrators would want this to be different. But the lapse of time only aggravates, in many instances, human rights violations. They fester. And that's what I meant in my intervention earlier, that while there have been a number of years that have passed since the shipment from Sweden to Chile in the 1980s, the case is not going to go away. It's not going to become stale. It's going to fester, and the urgency of the exposures is going to become even more visible as the latency of the chemicals in questions begin to cause the foreseeable harm. So that needs to be contrasted and articulated in legal terms in the treaty in regards to the statute of limitations, because it's often the case that countries introduce statute of limitations to secure some level of stability in social interactions. But when it comes to gross human rights violations and the exposure of a whole community to dangerous and hazardous substances can only be considered a gross violation, those statute of limitations should give way to the interests, the priority interests of a remedy in human rights violations. And so that's where the treaty has a role to play in ensuring that that statute of limitations are not a bar, do not constitute a bar to meaningful, to effective access to justice.
Thank you so much. For the next round of questions, we have a question to Liliana. Has any action been taken at the international level, such as the UN Human Rights Council? Another question from Frederick. Victims are people. Would the treaty also apply if there were no people who suffered directly, but substantial environmental harm was done anyway? For example, by not observing international environmental standards, and who in that case would be allowed to hold the respective TNC accountable? And the last question for Richard. Who were some of the other investors in Cowboy Lead Mine? Will they also be held accountable? So we have a question for each of the panelists. Liliana, if you would like to begin.
Yeah, I can answer very briefly to the first question. Yes, there is a list of issues submitted to the working group for business and human rights about this case on Swedish to the Swedish report, also to the Commission on Economic and Social and Cultural Rights. Actually, very recently in October, with a list of articles elaborating the case. And a lot of information that I used for this presentation is taken from that dossier. So many things are happening, but the reaction from the Swedish government it's very slow. So as I just said, the presentation, only the visit from the Swedish ambassador was done this year. For the rest, it stays very silent. And for the rest, it's a kind of a solidarity movement, which is, well, the documentary group, but many organizations are joining, supporting the community and all these reports that they have to produce, because as I said, someone said before, it requires a lot of different capacities that are difficult and expensive to gather for vulnerable communities. So yeah, that's more or less what's happening.
Thank you. Marcos, if you would like to answer regarding the environmental harm question.
Yeah, I'm happy to. It's a very interesting question. So the question, could this instrument provide protections or accountability for environmental harm that does not affect humans, that is caused by private entities? The answer depends on the understanding of the extent of human rights. The mandate of the working group that's negotiating this instrument is to draft an instrument in respect of human rights. And so, do human rights encompass only environmental harm when that harm affects humans, or does it also encompass the environmental components without a link to humans? Now, there's two large school of thoughts here. One could be said to have been inspired or motivated decisions by the European Court of Human Rights. that is under the European Convention of Human Rights, hearing environmentally related cases under right to life, right to private life and family. And in the jurisprudence of the European Court, environmental harm that is not affecting humans is not cognizable under a human rights frame. And this interpretation can be contrasted with the Inter-American Court of Human Rights, for example, which delivered an advisory opinion on human rights and the environment, where it analyzed the components of the right to a healthy environment in the San Salvador Protocol and by way of and its incorporation into the American Convention on Human Rights. And the Inter-American Court reasoned that the right to a healthy environment protects the components of the environment, regardless of whether humans are also impacted. Now, this is a broad notion of interconnection
in the Anglo group, and another was Anglo American Central Africa, obviously also in the Anglo group, which are companies that no longer exist. But the point I really want to emphasize, as I tried to in my talk, is that this question of legal liability is not about investment. It's not about shareholding or any other form of investment. And to suggest that it is really misses the point legally. What the legal cases against parent companies are about is the role that the parent company actually played, in fact, in relation to the local operations. Did it exercise control or supervision or management over those operations or relevant aspects of them? Did it give advice on technical and medical issues, as is alleged in this particular case? If it did those things, then liability can follow, depending on what actually emerges in terms of the facts, regardless of the degree of shareholding or investment. So as I say, just to emphasize again, it's not about shareholding or investment when it comes to legal liability.
Thank you. Just to also quickly note in regards to one of the questions for Liliana, Franciscans International helped support a submission to the Committee on Economic, Social, and Cultural Rights in regards to the case of Arica. And I just on that note, also before we get into more questions, even though we're kind of running out of time, I know we have Rodrigo Pino, who is from Arica, who will speak for just a very brief period, and we'll do the translation. Rodrigo.
Hola. ¿Se escucha? ¿Sí?
Sí.
Sí, te escuchamos, Rodrigo.
Perfecto. Hola, hola a todos y gracias por la invitación, antes que todo. Un par de preguntas a don Marcos o Liliana, y antes también muchas gracias a Liliana, expresado tan claramente. Ha tenido que dos preguntas de nuestras demandas acá en Arica frente al Estado sueco. Estamos hoy día en algunas conversaciones previas y las preguntas serían hoy día qué responsabilidad le cabría al Estado sueco, ¿ya? En esta problemática y también qué posibilidad legal existiría de nuestra intención de que los desechos suecos, ¿cierto?, regresen a Suecia. Entonces, porque justamente son dos acciones que nosotros estamos en tratativas con el gobierno sueco a través de su embajador. Entonces me gustaría a ver si don Marcos pudiera un poco iluminarnos o alumbrarnos respecto de estos temas.
I don't, Marya, he posted two questions actually directly to Marcos about the responsibilities of the Swedish government and the possibility for the repatriation of the materials, if that's possible. So I don't know if Marcos would like to answer those questions.
I'm happy to take a first stab. It is a big question, and it could give grounds to a whole discussion. But given the time that we have, already back in 1972 in Sweden, in Stockholm, the UN Conference on the Human Environment proclaimed a number of principles. One of those principles concerns the duty of prevention of transboundary harm. Now, that duty has since passed into customary international law. There is no question that it is at the core of international environmental law, the duty of states not to cause transboundary harm. Now, whether that duty encompasses the kind of situation that we have here, where the state is failing to exercise adequate control over a company that is domiciled in its jurisdiction and allows for the export of waste to another in a way that causes harm, that is precisely the question. Now, to address those types of situations, in light of the open textured character of the general obligation, countries in the world negotiated the Basel Convention. The Basel Convention on Transboundary Harm from 1989 was a response to the dumping of hazardous waste generated in Europe, in the African continent, and it set out to establish controls. And failure to observe those controls gave rise to criminal liability, including, among others, and among other obligations, the duty to take back the waste. In addition, the Ban Amendment was adopted soon after the adoption of the Basel Convention, which prohibits the transfer of waste from the global north to the global south. I'm oversimplifying, but in general terms, that's the Ban Amendment entered into force many years later. There's a lot of legal controversy around that, but it is now in force, and it gives expression then to what could be, as a matter of interpretation, at least, the duty to prevent transboundary harm in respect of the movements from industrialized countries to developing countries. Chile at the time was a developing country. Today it's part of the OECD, so there are legal nuances there as well. In terms of diplomatic claims and communication, my sense is that the Chilean government is in a very strong position to argue before the Swedish government that the international environmental law duties apply in this instance in respect of these facts. And so that would be the second part of the question. But again, I'm not doing justice to the complexity of the issues, only pointing out general parameters of and directions. Thank you.
Thank you. Due to the time, I'm unfortunately not going to be going through more of the questions. We have quite a bit in the chat box, and they are very interesting. But our colleagues that are in Geneva and also around the world are following the treaty session, which will probably restart quite soon. So I would like to give my thanks to the panelists today and encourage all of the participants to go to the websites of LIDE to follow the Cowboy case, view the documentary that Liliana suggested, and of course follow Marcos's mandate and follow the OHCHR website accordingly. We will be sending out today's website link or webinar link to everybody that participated. And again, thank you all, and thank you to the panelists.